As a prosecutor, I would sit in court on docket days on officer prosecuted cases. I'd see the judge call the cases one by one and then dismiss them one by one because the officers didn't show up to trial. But you don't have to be afraid. Officer prosecutions are not as difficult as you might think. In this video, I'm going to demystify officer prosecutions, and I'm going to explain step by step what the process is. Coming up. Welcome back, everybody. I'm attorney Eric Scramlin with Tactical Legal Solutions, and this is the Tactical In-Service Podcast, a podcast for law enforcement where I break down training topics and case law to help you, the law enforcement community, stay up on the law. In this episode of the podcast, I'm going to be talking about officer prosecutions. Now, I know that this is pretty unique to the state of New Mexico, but I also know there's a few other states out there that do this, and a lot of the tribal agencies do this as well. So what I mean by officer prosecutions is you are the prosecutor from start to finish. So in New Mexico, on some cases in the magistrate court, depending on if you have a city attorney or what your district attorney's office agrees to prosecute, you may find yourself as a police officer in magistrate court as the full-blown prosecutor on a lot of misdemeanors and petty misdemeanors. As a DA, I used to see countless officer prosecuted cases dismissed because the officers get overwhelmed. They don't know what to do. They don't know the rules. They get intimidated. They don't want to go up against defense attorneys, so they simply just don't show up, and then the case gets dismissed. Well, what I want to do with this video is do a real basic demystifying the officer prosecution experience, break it down into the process. So what is the process? How does it work? How do the stages go? And I think if you know and see how simple they are, that there's no reason why you can't go and do an officer prosecution from start to finish. Before I get started, since we're talking about officer prosecutions, quick announcement. April 6th and 7th, 2022, I'm going to be doing a training with the Southeast New Mexico Law Enforcement Academy in conjunction with the New Mexico Junior College down here in Hobbs, America on officer prosecutions. 2-day course. It is literally step by step from the moment of arrest all the way through to sentencing, how to do an officer prosecution. I'm even going to put you through a full-blown mock trial where you're going to prosecute the defendant the entire case with objections and everything. I think it's a really good course, and I think you'll leave it with a lot of confidence to be able to go out and start doing these and start training some of the officers, the younger officers that come in, on how to do these as well. So I'd love to see you there. I'm going to leave a link in the description below. At the time of recording this, I only got about 10 spots open, and it's expected to fill up pretty quickly, so you're going to want to check that link. If it's full, contact them. Let them know you want to do another one. If we get it filled up, we create some demand, then they'll set another one. You can also go to my website at tacticalattorney.com and contact me directly. I'll come to your department and do an officer prosecuted training there as well. All right, enough of that. Let's dive into this week's episode. So the first thing I want to talk about is let's just start from the very beginning. So as a police officer, your work is out on the streets. So you arrest someone. Let's say it's the classic driving on a suspended license with the arrest clause. So you stop someone for speeding, you cite them for speeding, find out they don't have a license, run them, it's revoked, arrest clause, revoked for DWI. So they're arrested, they go to jail, you go back, you draft the criminal complaint, all right? You had a body cam, so all that stuff gets saved. And then you're going to file that paperwork, and then what happens next? This is where the confusion usually starts for the officers. You think, I filed my paperwork, I'm done. I'll just show up in court. If they don't take a plea offer, then whatever, I'm not going to try anymore. They'll set it for trial, and I'm just not going to deal with it, and you don't show up for trial because we don't know the process. So let's talk about the process. We have the arrest, the paperwork's filed. What happens next? Well, the defendant's going to get arraigned. So the defendant's going to go in front of the judge within 48 hours, usually, much sooner than that. The judge is going to set a bond. They're going to get out of jail, and the judge is going to give them a piece of paper that says you have to appear in court for a pre-trial conference, and it's going to have a date on it. The judge is also going to send a copy to you as the police officer because you are the officer prosecutor on the case. you got to be paying attention and watching for this paperwork. I'm going to talk about at the end a system you can use to keep track of this stuff. So we have that pretrial conference that you have to show up to, or the case is going to get dismissed. But before we even get to the pretrial conference, there's some rules that are going on in the background. So the first rule I want to talk about is discovery. So if I want to direct my New Mexico officers, and let me bring it up here and I'll show you guys what I'm talking about. In New Mexico, I'm talking about Rule 6-504, discovery. So you'll notice if we look at A, and this is for magistrate court, which is where you're going to be prosecuting your cases. You could be in municipal court as well. The same rules apply there. So you'll notice here that it says, unless a different period of time is ordered the trial court within 45 days after arraignment or the date of filing a waiver of arraignment, the prosecution, that's you, shall disclose and make available to the defendant. And now we're talking about everything that you have that could be evidence in the case. So what is that? Well, it's your body cam. If it's speeding, then it could be your certification for your radar. It could be documentation showing that it's calibrated. If it's a driving on a suspended license, revoked for DWI, the paperwork from motor vehicle that you're going to have to use in the trial. It's all the stuff, all the evidence that you may have. You have to disclose that, meaning you have to turn it over to the defendant within 45 days of arraignment. Or if they get an attorney, they're going to waive arraignment. So really the clock's going to pretty much start running within 24 to 48 hours after you arrest. You got to make this stuff available to the defendant. Usually your pretrial conference is going to be before that 45-day period. That's a perfect time to bring all your evidence to court and turn it over to the defendant. Literally, make a copy of the body cam, make a copy of anything else that you're going to have that could be evidence, and give it to the defendant. Have them sign a piece of paper saying, I disclose this, because they'll claim they didn't get it. So make sure you follow this. This is kind of the first rule in the background that a lot of officers aren't aware of. If you don't follow this rule and you show up on the day of trial with a bunch of evidence and you didn't turn it over, then the judge can exclude it and not let it come in, which essentially means the case is over. So very important rule. Definitely one you got to know. All right, so that's the discovery rule that's kind of going on in the background. There's a couple other things that you're going to want to think about before you get to the pretrial. And then, by the way, let's talk about the pretrial for a second, then I'll talk about these other things that are going on. So at the pretrial conference, that little piece of paper where they show up, the judge wants to see you guys accomplish two things. Is this going to be a plea? The judge needs to know. And if it is going to be a plea, it needs to get done today. We're not waiting. We're not giving them more time. You can agree when it's reasonable to a continuance, but you're going to want to make them waive that 6-month trial rule, okay? But usually you're going to want to get them to plea that day or set it for trial. Now, if you offer a plea and they reject it and it's set for trial, it's time to start getting ready for trial. The other thing that the judge is going to want to know on the pretrial conference is, have you followed the discovery rules, 6-504? Have you turned over your evidence? It's probably been 45 days or close to it. So have you done this? What a great opportunity to say, Your Honor, I have a piece of paper here. I brought all my evidence and turned it over today. Great. You're done. So that's a couple things going on in the background in an officer prosecuted case. You've arrested the person. You filed the paperwork. You got 45 days to turn over your evidence. Usually, the pretrial conference is going to happen within those 45 days. That's a perfect opportunity to bring your evidence to court, physically hand it over to the defendant, have them sign a piece of paper saying that they got it, and then notify the judge. Now, if you can resolve it by a plea, get it done that day, that's it. Case is done. You can move it out of your paperwork, out of your folder, and it's all done. Now, if it doesn't resolve that day and it's going to get set for trial, there's a few other things you're going to have to do now. So I'm going to go back to Rule 6-504 here, and a couple other things you're going to have to do. Let's look at C, 6-504C, witness disclosure. So unless the judge gives you a different period of time, again, you have 45 days after that arraignment. The prosecution, that's you, shall, when you see the word shall in legal language, it just means must. It means it's not optional. You have to do it. You must provide to the defendant a list of the names and addresses of the witnesses that the prosecution intends to call for trial. Now, I'd say probably in 9 out of 10 of your officer prosecuted cases, you are going to be the only witness, but you're still a witness, so you got to disclose that. So what you're going to do now is I'm going to show you Form 9-417. You're going to disclose a witness list. You can see the witness list. You need the name of the witness, the address, telephone number, and then it says statement, yes or no. Sort of a new addition to the rule here. What that means is this witness someone that gave a statement? So if it's just you, you're going to list your name, the department address is fine, the department telephone number is fine, and did you give a statement? Yeah, you probably did because you're probably recorded on a body cam. So it's almost always going to be a yes. It's not a whole, for you in an officer prosecuted case, I can't imagine a lot of reasons why you'd call a witness that's didn't give a statement. So that's a yes there because the court wants to know, is there discovery? If there's a body cam or something that recorded it, that's something that's got to be turned over. So this is something you got to file. So you're going to have this form. You're going to have to fill it out. All right. And then, by the way, also, do you have any evidence? So your body cam would go here. In a suspended license case, your return that you'll have to apply to the motor vehicle to show and prove the certified record that it is actually suspended. You list those things here. All right, location, it's at the department because now you have proof that you followed the rules that we just talked about. Within 45 days, you have to do this. Now, it's not a hard and fast rule. You should do it within 45 days, but there's some leeway. If you show up to the pretrial conference and it's been 50 days and you turn all the stuff over, it's not going to be a problem, because the defense has to show prejudice. It's not an automatic thing, but you should always strive to get both of these things done within 45 days. All right. So once you have that filed, so we got witness list, we got exhibit list. One other quick document I'll show you guys here is a certificate of disclosure of information. So this is sort of optional if you want to file this. Remember I said you're going to have the defendant sign a little piece of paper. It says they got the evidence. Well, you can fill this out showing that you complied with the rule, fill it out, and then file it with the court, send a copy to the defendant. You don't have to, but it's not a bad idea. All right. We're coming down the stretch here. So you filed those things. You followed Rule 6-504. Trial approaches. The only other thing you may have to worry about is witness interviews. Again, that's in Rule 6-504. If the defendant wants to interview you, then you have to make yourself available for them to interview you. If you don't, then you're not allowed to testify. By the way, you can also request a witness interview of any defense witnesses. Now, you can't interview the defendant because they have a Fifth Amendment right to remain silent. But if the defendant files a witness list and lists some witnesses, maybe it's someone's going to say that they didn't do it or have an alibi or whatever, then you can request to interview that person as well. So it goes both ways. Just make sure you follow it. And that's it. You're going to come up on the day of trial, and if you didn't follow those rules that we just talked about, then it could be problems. The case could get dismissed. The judge could prevent you from testifying, may not allow evidence in. So it's important that you know and understand Rule 6-504 and understand that you got to file some of that paperwork well before trial. It's not that difficult. What I recommend you do is simply create a system or a process. Your district attorney's office has a case management system that's essentially a cloud-based system where they put everything in and it keeps track of all this stuff. If you're lucky enough, you'll have a liaison at your department that will help with that. If you're sort of on your own, what I'd recommend is you check out a platform software called Evernote. It's free up to a certain amount of memory. It's a cloud-based, basically it's a case management system that you can use to keep track of your cases. Just come up with a system where you're keeping track of the stuff and making sure it's getting filed, because like I said, if you don't file it, it could be problems. All right, so quick recap here. Officer prosecuted cases. What's the process? You arrest, file the paperwork with the court. They're going to get arraigned within 24 to 48 hours. You now have 45 days to turn over your witness list, any evidence that you have in the case, and those papers that you need to file that prove that you've complied with disclosure, and your witness list, file it, and your evidence list, file it. You can turn over all that stuff at the pretrial conference and file it then. You want to try to hit that 45-day window, and if you don't, get it in as soon as you can. All right, and then if there's a plea offer and it's accepted, it's done. If it gets set for trial, Then maybe there's going to be some pretrial interviews. You're going to prep for trial. You're going to show up ready to go. If in that trial period you hadn't complied with discovery and there's still evidence out there that needs to get turned over, get it turned over as soon as possible. That's essentially it, guys. It's not a ton of stuff and a ton of paperwork. We're talking about a couple of documents here that need to be filed and a couple of simple rules that you just need to follow. Then we come to the day of trial, and that's a whole new podcast episode. So again, I'll remind you, if you want to learn how to actually do the trial, the objections, opening statement, all that stuff, April 6th and 7th, down here in Hobbs at the Police Academy. I'd love to see you guys at that. It's going to be really fun. I hope this helps demystify officer prosecutions. Leave me some comments. What issues are you having with officer prosecutions? What is it about them that terrify you? Maybe there's some misconceptions. Hopefully this kind of starts to demystify it a little bit. Feel free to ask me any questions. Reach out to me. Let me know. I'd love to help you guys out. I don't like seeing these cases getting dismissed one after another. I want to see you guys in there doing these. You're capable of doing it. I know I've worked with law enforcement my whole career, and these are not the hardest things. It's just understanding the process and getting in there and doing it. I hope this helps. Don't forget to hit that subscribe button so you can stay up on the law when all my new episodes come out. Until next time, stay safe out there, guys. Remember, every battle is won before it's fought.